Okay, Gary Davis and Holly Tomchey. Holly is one of the more experienced higher ed attorneys whom I've worked with, and I am happy to have her with us today to follow up on our previous conversation. Holly, can you touch on some of the hot topics? In 2015, we're looking at some emerging issues in higher ed law. What would those be?
Right. Well, no one has any money, right? So colleges generally rely on adjuncts when there's not enough money to hire full-time tenured faculty. So the numbers in adjuncts are increasing, and the number of adjuncts that are unionizing is increasing.
These are part-time faculty members.
Part-time faculty members,
Yeah.
correct. So there's a host of issues that come along with the increase in part-time faculty. So from bargaining, unionizing and bargaining, the issues associated with bargaining those contracts are quite different than the full-time faculty. There's limitations some states have on how many hours they can work. There's considerations under the Affordable Care Act and what constitutes full-time. 30 is the new 40 now. So there's a lot of different issues that one must consider when working on those contracts with the adjuncts.
Yeah, there was one college in Illinois that just decided to take some radical steps in terms of discontinuing the services of certain adjuncts because of the fear that there might be lawsuits if they didn't do that, right? And then there's been the battle in the public. It's turned into a public relations issue for the college. So it starts as a legal issue and then it gets even bigger, right? Sometimes.
Right, particularly what folks refer to as the double dipping in the pension, right? If you have a faculty emeritus who's earning a pension, they come back to teach on a part-time basis. Some states are really classifying that as double dipping.
So if a college is going through the development of a policy on the employment of part-timers or adjuncts, it wouldn't be a bad idea to have a college attorney sit in on those discussions so that they don't design a policy that's flat out in conflict with emerging laws.
Absolutely.
Right? Okay.
Absolutely. A lot of issues are coming across both from the employee and from the student aspect for Section 504 or the Americans with Disabilities Act. So what constitutes a disability and how that is evolving and what's considered a reasonable accommodation these days. It used to be the access under the ADA that was the hot topic, but now it's how do we enable the student to learn in the classroom just like any other student. How can we accommodate him or her without spending all our budget dollars?
It started out as a law for people in wheelchairs who couldn't get up and down stairs, but now it's moved over to questions about people who have learning disabilities, right, or Tourette's syndrome, and they interrupt classes with their outbursts and that sort of thing. Can they be ordered out of a program or a class when they have that disability?
Right.
Yeah, a lot more complicated than we thought when we started.
A lot of case-by-case analysis for certain.
Yeah. Okay, what else?
So Title IX, there's a lot of Title IX issues out there, from equal opportunity for men and women in sports to the unfortunate sexual assaults on campuses.
Yeah, Title IX, I always tell the students, started out as a joke. During one of the civil rights debates in the Senate, one of the senators from the southern part of the United States, to mock the civil rights law, said, well, why don't we just, as long as we're protecting African American people, protect women too. Let's put in a law that says you can't discriminate against women. Ho, ho, ho. And before he knew it, the law had passed and it was enacted and it's signed into law, and we've had Title IX ever since.
Right. Along those same lines, while it was in place before I was in college, it really became enforced in athletics in the early 90s. And as a freshman, the women's soccer team at Vanderbilt, we had to wear the men's hand-me-downs uniforms. By my senior year, we had our own brand new uniforms.
Yeah, things have changed.
Title IX.
Things have changed in athletics, and they're changing in other parts of the university and college too.
Yeah.
It's an emerging area of the law. Okay, what else?
So I think it's not yet hit here in Illinois, but California recently passed, or early 2015, an anti-bullying law, which prohibits abusive conduct. And in most other states, abusive conduct, if based on someone's membership in a protective class, is illegal, but not just being what we call an equal opportunity jerk. But that has now passed in California, and perhaps more states will adopt laws like that, and I think that will be an emerging trend.
Good. What else?
So due process for students and discipline, always an issue. That area of a law evolves, and you have to have a solid policy in place that you follow.
With procedures attached to the policy, we always emphasize
Absolutely.
that.
People need the time to prepare and be able to cross-examine witnesses and the like. Right?
And training for people on those procedures, right?
Absolutely, absolutely. That helps in the long run. So, and also in terms of decreasing dollars for education, I see colleges reaching out to do workforce development and entering into contracts with corporations to either train the corporations people or get folks ready for a trade and have specialists come in and teach the students. That requires a whole host of different contracts, partnerships,
Right.
independent contractor relationships.
And you could end up working with a company that has a policy that's in conflict with your own policies. Abercrombie and Fitch, I think it was, just lost a case in the U.S. Supreme Court over their denial of employment to a woman who wanted to wear, she was Islamic, a hijab. So, if she has a right to wear the hijab at Morton College, then she has the right to wear it during her workforce program at Abercrombie too, right?
Right,
Yeah.
interesting.
Yeah. What else?
So, and lastly, I'd say the deferred action childhood arrivals. So the DACA students for short, along with the undocumented students and
Hadaka, did you say?
DACA,
DACA.
DACA, deferred action childhood arrivals.
Okay, well, explain what that is. What is that law?
Can we do that after the break?
Sure.
Okay.
All right.
But your struggles with the undocumented students, and everybody I think is very clear on what dollars they're allowed to get, no federal dollars. But how do you sort out your policy towards undocumented students
Oh,
if they
I
want
see
to
what you're
be
getting at. Sure.
in programs that require a social security
Okay.
or a fingerprint, like a nursing program and the like.
I get it now. Okay. All right. What else?
So you've got your regular, your FERPA and your FOIA and your Open Meetings Act compliance issues.
So some of these are perennial, right? They've been around a long time.
Right.
But that doesn't mean your new employees understand them.
Exactly. Those, you ought to have training, at least every 2 years, I would recommend.
Okay, good.
Right.
Well, thanks. If I come back in a year, it'll probably be a slightly different list. Some of the items will reappear, but it's always a learning game, right? For a college attorney.
It is, and that makes it exciting.
Yeah, I'd hate to do the same thing every day.
Exactly.
And you don't have to.
No.
Thanks again for being with us today.
Thank you, Gary.
Okay.
I had to punt.